Okay, I think we'll make a start this morning. So, hi everyone, and welcome to BDB Pitman's first employment law webinar of 2024. I'm Nick Lariche, and today we'll be trying to anticipate everything that we can expect in the world of HR and employment in the next 12 months. What will be the key legal changes, important cases, consultations, and trends that we should all be looking out for this year? Tea leaves and crystal balls at the ready this morning are Aston Hawkes, Zoe American, who will guide us through all the different legislative changes that will be happening this year, while Charlotte Nugent will be discussing all the key employment judgments that will shape 2024. Now, for a bit of a change from recent years, there isn't as much crystal ball gazing necessary in the next few months, because much of the employment law changes that have been talked about coming into force will finally become reality this year. Aston and Zoe will provide more details in a sec, but we know for sure that changes to flexible working, the introduction of carers leave, greater protection for those returning from family leave, and the new duty to prevent sexual harassment will all be coming into effect in the next few months. If these changes on their own weren't enough to keep HR teams busy, the government decided to add a few extra new changes into the mix as well, including changes to the TUPE regulations and extensive changes to holiday pay. Now, anything to do with holiday pay tends to be really complicated, but as Zoe will be setting out, for once, these changes should actually make this area more straightforward for organisations and remove a fair amount of the complexity. They are, though, well worth getting your head around because some of the changes are pretty far-reaching. This all means that 2024 should be a very busy year for employment law, and that's without the possibility of a general election at some point this year. Before Aston starts and kicks us off, I'd like to cover just a couple of housekeeping points. We've got all the usual Zoom buttons at the bottom of your screen, and I'd just like to highlight the Q&A button in particular. This is where you can ask questions about what we'll be talking about today, and we'll get a chance to discuss these at the end of each slot. If there are questions that we haven't had a chance to get to today, then we'll send all of our responses together with today's slides and a recording of the webinar out to you in the next few days. But I'm hoping that we'll get through quite a few questions. So please do ask anything that comes to mind as we're speaking, as we'd love to hear from you and to hear your thoughts on what we're talking about. Just make sure that you do use the Q&A button and not the chat function. The chat function can be used if you're having any technical issues, and Megan in our team will try to help. Now, I think those are the main housekeeping points for now. Thanks very much for joining us. And I'll now hand over to Aston to kick things off.
Thanks, Nick. Good morning, everyone. Thank you for joining us. As mentioned already, I'm Aston Hawkes, and I'm going to talk to you about some of the upcoming changes in legislation in the next 12 months before I hand over to Zoe with a few more updates. So you'll see on the first slide on your screen the top 5 hot topics for 2024, some of which you might remember from our 2023 update. The main focus amongst these topics is facilitating a more family-friendly and inclusive workspace. I'm going to take you through each of those in turn based on the information we have presently available. And at the end of all of our updates, we will have a summary about when each change is expected so that you can mark all of those in your calendars. Next slide, please. So the first hot topic here is extended protection in redundancy, so specifically in relation to maternity. In our update last year, we were talking about protection from redundancy, pregnancy and family leave bill, but we now have the full legislation in the form of the Protection from Redundancy, Pregnancy and Family Leave Act 2023 and the Maternity Leave, Adoption Leave and Shared Parental Leave Amendment Regulations 2024. So what does that new legislation say? Essentially, there will now be protection from the point at which an individual notifies their employer of their pregnancy, whether that's verbally or in writing, until the date 18 months after the birth of the child. In cases of miscarriage before 24 weeks, there will be protection from the point at which the individual notifies their employer of their pregnancy, again, whether verbally or in writing, but it's only until 2 weeks after the end of the pregnancy. For miscarriages after 24 weeks, legally this is classified as stillbirth, and as such, the longer protection of maternity leave would apply. For adoptions, protection commences from the beginning of adoption leave until 18 months after the placement. And finally, for those on shared parental leave, protection commences at the beginning of shared parental leave and ends for those taking fewer than 6 weeks of shared parental leave at the end of that leave itself. But for those taking more than 6 weeks of shared parental leave, 18 months after the birth of the child. There is one caveat to that for shared parental leave. So if employees in question are also taking maternity or adoption leave, in addition to that leave, those periods of protection will apply instead. So in practice, they'll get that longer period of protection in those circumstances. You'll see a table on the slide just summarising those points because there are some differences amongst the different groups. So we say protection, but what does that mean? The protection here is that these groups will gain priority status over other employees in a redundancy situation when it comes to suitable alternative roles. So this means that if you've got suitable alternative roles available, then they have the right to be offered such a role before they're made redundant. So when is this something you need to think about and start worrying about? The changes will apply for adoption and maternity leave ending on or after 6th of April 2024, to pregnancies notified on or after 6th of April 2024, and to shared parental leave of at least 6 continuous weeks commencing on or after the 6th of April 2024. So there's a clear date to be looking out for, but it's important to start thinking about policies and procedures now and equipping your managers with knowledge as to what to do if a pregnancy is disclosed to them, or recapping this process if you've got relatively robust procedures in place already. Training is recommended in this respect. Having a method of capturing the data in terms of protection periods will be really important, particularly if you've got employees that are making disclosures verbally or letting colleagues know informally about their news. The regulations aren't crystal clear about what will amount to notification, so having that framework in place before the changes come into place will be really important. In addition, if there are any restructures looming in the future, this is definitely something that you should be considering in planning. A wider group of people are obviously covered here than at present, and it's also a longer period time-wise in terms of the protection. So having a good system in place to identify potential suitable alternative roles will be really important. And considering clear selection processes where the number of individuals that you have that are entitled to those roles exceeds the number of vacancies that you have will also be really important. So the penalty for getting this wrong can be that employees will have a claim for automatic unfair dismissal. What that means is that the compensatory award that they could get if they were to be successful is not capped like it would be with an ordinary unfair dismissal standalone claim. They could also bring a discrimination claim. So it can be very costly in terms of both management time and obviously the money aspect too.
Thanks, Aston. Reading some of the reports about these changes makes it sound like you can't make people redundant returning from family leave. Have they got it right or wrong here?
In short, no. So I think sometimes the level of complication in the legislation and the different dates that are all interplaying can make it a bit confusing. And so I do think sometimes you get a bit of misinformation in the mass media. Let me start by saying that you can make people redundant if they are, during their pregnancy or maternity or adoption or parental leave. And that's not going to change in April. But it has to be a genuine redundancy situation, and the individual can't have been selected because of that category. There are risks in the process in that the individual might assume that that's the case anyway, though obviously this is less likely if we're looking at a workplace closure redundancy. But the important thing, as it is presently, is to be able to demonstrate the true and fair reasoning in the process. It's just an extension of the existing framework, a longer period of time and a larger group. So the main issue is just to keep track of those dates and the vacancies, so that the process is managed precisely and that you've got that justification if it were to be questioned later.
Yeah, and it's also, it kind of does apply to suitable alternative roles, as you flagged it up on the screen. I think that's important to bear in mind too.
Yeah. Great. Next slide, please. Okay, so moving on to the next hot topic, which is neonatal leave and pay. So in our last update, we were again still at the bill stage, but we now have the Act, which is the Neonatal Care Leave and Pay Act 2023. However, the regulations are actually not expected to come into force until April 2025, and that's likely because of HMRC and payroll changes to give them time to be put in place. So what does the Act say? It will provide parents with the right to up to 12 weeks annual leave if their baby requires neonatal care for at least 7 continuous days up to the 28 days after birth. This will be in addition to other types of family leave that they already have available. The right to leave will be a day one right, but there's only a legal entitlement to statutory pay for employees who have worked for their current employer for at least 26 weeks. The leave itself must be taken within 68 weeks of birth, and employees will also be protected from dismissal or detriment as a result of taking that leave or in conjunction with the request for that leave, as well as having the right to return to their role. Any dismissal connected to neonatal care or leave will be automatically unfair. So what should you be looking at now, given that we have until April 2025 for this? So at this early stage, it's definitely worth looking and considering at putting in place a neonatal care policy, particularly given the distinction here between pay and leave, to make that abundantly clear. You could also consider whether it's preferable to provide something in addition to the statutory minimum, certainly in terms of employee benefits. And as I mentioned, payroll, it's definitely worth getting those pay slips and pay slip procedures up to date too. Next slide, please. So moving on to a further type of leave, which is carers leave. Again, we now have the Act in this respect, when we were still looking at the bill into late last year. So we now have the Carers Leave Act 2023. And as of April, again, we will have the Carers Leave Regulations 2024. So what does this new legislation provide? From the 6th of April, there will be an introduction of a right for unpaid carers leave of up to 1 week in any period of 12 months. This is a right to provide or arrange care for a dependent with a long-term care need. A dependent here is a spouse, civil partner, child, parent, person who lives in the same household other than an employee or a tenant, boarder or lodger, or a person who reasonably relies on that employee for care. A long-term care need is an illness or injury, whether it's physical or mental, that requires or is likely to require for more than 3 months care from that individual, a disability under the Equality Act, or issues relating to old age. Getting into the more specific details of this right, this is another day one right, and there's no need to provide any evidence of the care here. So this is likely because it's unpaid. However, it's only 1 week of leave, no matter how many dependents we're looking at. The leave can be taken flexibly, but it must be taken as a minimum of half a day in each occasion. To take the leave, you have to give twice as much notice as the amount of leave that you want to take, unless you're asking for a half a day or 1 day, in which case you have to give at least 3 days notice. However, that notice doesn't need to be in writing. Interestingly, employers aren't able to decline a request altogether, but they can postpone the leave by up to a month if the operation of the business would otherwise be unduly disrupted. There will also be a protection from detriment and dismissal as a result of taking or in connection with this type of leave. Compensation here will be whatever is just and equitable in the circumstances, taking into account employer behaviour and any consequential loss. This is definitely another topic for employers to consider in the review of existing employment policies and in terms of whether any protection beyond the potential statutory entitlement may be something to explore. It also underlines the need to make sure requests of this nature are tracked. So self-certification forms and record keeping will be very important, given that notice, again, doesn't need to be in writing. You may want to implement training too for managers on this issue, particularly if we're looking at requests and how to handle those in a sensitive and confidential way. Next slide, please. So moving away from leave now into issues of harassment. So we're expecting formal amendment to the Equality Act in October of this year by way of the Workers' Protection Amendment of Equality Act 2010 Act 2023. Under the scope of the Act, the employer is to be treated as liable for harassment of his employees in the course of their employment by third parties over whom the employer does not have direct control, if that employer failed to take reasonable steps to prevent that harassment. For these purposes, a third party is another person other than the employer or another employee. The definition of harassment is the same as the one currently contained in the Equality Act, but the duty will be enforced here by the Equality and Human Rights Commission, and non-compliance potentially leads to a range of outcomes such as litigation, investigation, and enforcement action. If an employee successfully brings a claim for sexual harassment before an employment tribunal and a finding is made that the employer has breached this preventative duty, the tribunal will have power to also award a compensation uplift of up to 25%. This will be a new proactive duty on employers to take all reasonable steps to prevent harassment of their employees in the course of their employment, and there's a shift here from reaction to prevention. Given the implications for employers here financially, it's very important to start reviewing policies and training in the workplace and to have a look at those contracts that you may have with third parties who employees may be in contact with in the course of their work. It's worth inquiring what training and provisions any of those third parties have in place to understand the risk, and the earlier you start to do so, of course, the more prepared you will be. Similarly, making sure that adequate systems are in place and kept under review. So here, reporting, record keeping, and potentially a helpline for making those complaints will be very helpful. And finally, making sure perpetrators of harassment are dealt with expeditiously and fairly will become increasingly important. So you may want to review things like your disciplinary policy in line with other updates. Next slide, please. So the final hot topic from me is flexible working. So we're about to have the Employment Relations Flexible Working Act 2023 coming into force. So this has been the subject of media attention and quite a lot of media misinformation over the last few months. So what will the Act do? It will introduce a new right to request flexible working from day one and make a number of changes to the existing flexible working request framework. So notably, there will be a requirement for employers to consult with employees if considering rejecting their flexible working request. There will be permission for employees to make 2 requests in 12 months rather than 1. There's a reduction in the period for employer responses from 3 months to 2. And there's also going to be a removal of the requirement for employees to specify in their request how the employer might deal with the effects of that request. There's also an updated ACAS code of practice and non-statutory guidance on this to support the Act itself. And the changes will come into force and into effect from the 6th of April 2024, including that code that I mentioned. So it's definitely time to start looking at procedures at this early stage to make the revised process smoother once those changes are in force. It's likely that enthusiasm to put in requests may spike in the springtime if the media starts to discuss the right again. close to coming into force. So it's definitely worth doing that homework now.
You mentioned all the kind of the media attention that these changes have kind of generated. Do you think they're actually going to have as much of an impact as the media have maybe been making?
To be honest, not really. There's definitely been a lot of focus on this being a day one right, but the fact that it's a right to request from day one rather than the right for that request to be granted seems to have been a bit lost in translation. The main impact is probably going to be in terms of that administrative burden that I mentioned. So you may see more requests coming in, particularly in the spring, but also generally, and you may have to do a little bit more work in terms of working out the impact on the business, because that onus has shifted from being on the employee. And the reduction in time to respond will probably have a bit of an impact too, because at the moment that 3-month period that you have is to have any consultations you might have, deliver the original outcome, and then deal with the appeal process and any appeal outcome. So when you factor in things like internal escalation and holidays and sickness and things that usually do just slow down these kinds of processes, that when you've got 1 month less to deal with it, it's definitely going to be important to keep track of dates and make sure things are dealt with efficiently.
Right, and we've had some good questions from the audience today on some of the things that you've been talking about. Looking at the enhanced redundancy protection, will employees now in those kind of situations get priority for roles in a pooling scenario?
So realistically, it's when you're looking at priority for roles themselves, the roles have to be available in the first place. So if you've identified some that are available, then those are definitely going to be ones that you're going to give them priority for. If you're looking at a pooling situation, then of course, what you'd be looking at the roles at a very early stage, right before you've actually made that redundancy decision. So it would depend where you are in the process as to whether that individual is necessarily going to take the role, of course, but it's making sure that you've given them priority before you make that decision to make them redundant. I mean, if you're in a pooling situation where the individual may not actually be made redundant in the first place, then it removes that requirement to consider them for the role, but it's something that you should be looking at on an ongoing basis.
Excellent. And again, we've talked about employees. Is this going to have kind of any impact on kind of contractors or temporary staff? I'm kind of thinking of maybe the flexible working changes in particular.
Sorry, could you repeat that one?
Yeah. In relation to kind of contractors or temporary staff, do you think some of the changes that you've just talked about will have an impact on them too, or are we looking at just really employees only?
I think certainly in the commercial sphere, we are moving towards a more family-friendly concept, and I think that will spill into the contractor situation. I mean, obviously, they won't have the same rights per se, but they might be looking at different working arrangements that they might want to have in place. So it may be that the amount of time that they're willing to commit to things may be slightly different. It may be that they're looking for more flexible arrangements themselves. But equally, it might swing the other way. So if employees are less available, there may be more of a desire to get contractors in if they are more able to commit to particular time periods that they can conduct particular tasks for businesses.
Just one more before you hand over to Zoe. So in terms of the day one right for flexible working, do you think that kind of impacts flexible working requests from job applicants who have been offered a role but haven't started yet?
So, I mean, in terms of it affecting them, I think it may be that if you've got people that are interviewing for jobs that may start sort of shortly after this has come into place, it may be that they don't necessarily put on your radar the kind of hours that they might want to be working, or days that they might be wanting to work, until they start employment, at which point they might just put in that request on day one, and that would be their right to do so. But as I said, it's only a right to request. So it's not necessarily the case that you'd have to grant that. So I suspect that may be a trend. However, I think that in a post-COVID world, a lot of people in the recruitment stage are putting on employers' radars what they would be looking at in terms of sort of commitment, certainly to days in the office and hours at that early stage, which allows you to have more of a sort of comprehensive conversation about that, particularly as a lot of job adverts are sort of advertising whether roles are remote, or if they have any options to work from home and such at that point. So I don't expect there's going to be masses of difference in that respect, because I think, yeah, it's not a massive extension of the existing rights. And as I said, there's always the option to say no.
This might make people just that much kind of more confident or keener, kind of raising those issues kind of early, because they know that they can do it from the moment they are actually employed. Yeah. So cool. Thank you very much.
Okay, well, that's everything from me for now. So thank you very much for listening, and I will pass things over to Zoe, who will give you a few more updates.
Thank you, Aston. Good morning, everyone. Go to the next slide, thank you. So there's quite a few other updates from me this morning. So we'll go through a flying speed, hopefully, and do a summary of each for you. Got them all listed 1 to 7 there. So we got the next slide, please, Megan. So first up, fair allocation of tips. So that's coming in on the 1st of July 2024 is when we're expecting to see it. The consultation on the draft statutory code of practice on fair and transparent distribution of tips is still currently open, and it remains so until the 15th of February. The Act will apply to qualifying tips, so they are defined in the code as tips which the employer has influence or control over, whether paid in cash or by card, rather than those where an individual receives and keeps cash tips with no employer involvement. So how should they be treated? There should be no deductions. Qualifying tips cannot be subject to deductions beyond those required by law. There should be a fair allocation. The allocation of qualifying tips will be based on the total amount received and must be fairly split between the employees at the location where they were earned. It is important to note, though, that fair doesn't necessarily mean equal when you're working what that should be for each person. There should be a written employment policy. So employees need to have a fair and clear written policy that details how qualifying tips will be fairly allocated to staff. The policy should be easily accessible by staff and include procedures in resolving any disputes. There should be records, so employers will be required to keep a record of tips and how they were allocated. These records should be maintained for at least 3 years and be made available to staff within 4 weeks of them making the request to see those. In terms of the period for payment, employees must ensure that staff receive their tip payment within 1 month following the month in which the customer gave the tip. So in relation to agency workers, so staff who are not directly employed by the company, such as agency workers, must also receive a fair share of the tips without deduction. In circumstances where the tips were paid to an agent, the agent is prohibited from making any deductions too. And in relation to redress, if anything, any complaints are made, where an employer fails to implement a policy to fairly distribute tips as per the requirements of the Act, an individual can make an employment tribunal claim. So next, please, Megan. Thank you. So next up, we've got TUPE consultation. So previously, there was a requirement to elect employee representatives for consultation of an TUPE transfer where appropriate representatives were not in place already, say for micro businesses where they had fewer than 10 employees. And this has now changed, meaning that employers can consult with employees directly in 2 different situations, provided that there are no existing representatives in place already. They are where the business has fewer than 50 employees, irrespective of the size of the transfer, or where the proposed transfer involves fewer than 10 employees, irrespective of the size of the business. And this applies to transfers taking place on or after the 1st of July 2024. Next slide, please, Megan. Thank you. So working time regulations, there are a lot, as Nick mentioned, updates coming in this section this year. So I've got a summary of those there, what you can expect to hear from me in a moment. And then I'll fire through each one in a bit more detail, explaining what it is and the effect of that. Megan, if you could, next slide, please. Thank you. So first up, reintroducing rolled up holiday pay for irregular hours and part-time year workers. There will be a new holiday system for workers that have irregular hours who work part of a year. These rules will apply to holiday years starting from the 1st of April 2024. So you may not actually be impacted immediately. For example, if you operate a calendar holiday year, then the rules won't apply to you until January 2025. So in terms of the definitions of irregular hours and part-year workers, irregular hours are the number of paid hours worked in each pay period of a particular leave year under the terms of their contract, wholly and mostly variable. In terms of part-year workers, under a term of contract is required to work part of a leave year in circumstances where there is a gap of at least a week in which they are not required to work and are not paid. So the new system will mean that workers with irregular hours who are paid part of the year will accrue holiday entitlement at the end of each pay period at a rate of 12.07% of hours worked and can be paid holiday on a rolled up basis. So rolled up basis holiday is where an employer adds a set figure to a worker's normal hourly wage, which is counted as their holiday pay instead of paying them when the worker actually takes their holiday. So as you'll probably appreciate, this practice was previously unlawful in the UK following a decision by the European Court of Justice, and they held it was unlawful because it discouraged workers from taking their holiday as they would not actually receive pay when they took the leave. Irregular and part-year workers will accrue holiday during periods of sick leave and family leave using an average of a 52-week reference period. Next slide, please, Megan. So normal remuneration. So from the 1st of January 2024, employees have been required to maintain full normal pay levels for at least 4 weeks of an individual's holiday entitlement and allow workers to carry unused holiday in certain circumstances. So what is normal remuneration for the purposes of 4 weeks EU leave? It must include payments, including commission payments, which are intrinsically linked to performance of tasks which a worker is contractually obliged to carry out, payments for professional or personal status relating to length of service, seniority or professional qualifications, and payments such as overtime payments, which has been regularly paid in the 52 weeks preceding the calculation. Next slide, please. So in relation to carryover of holiday pay, the regulations codify existing EU and domestic case law regarding carryover of untaken holiday. All workers will be permitted to carry forward 4 weeks of Regulation 13 holiday into the following holiday year, where they were firstly unable to take holiday due to sickness absence, or not given a reasonable opportunity to take holiday and were not encouraged to take their holiday, not informed that they did not take their holiday in the relevant annual year that they would lose their entitlement, or wrongly treated as self-employed and therefore not given paid holiday. Where a worker has carried forward holiday because they were unable to take it to sickness leave, they must use it within 18 months from the holiday year in which it accrued. And a worker who is prevented from taking holiday due to family leave may carry their full 5.6 weeks entitlement, which must be used by the end of the following leave year. Next slide, please. So record keeping, a previous decision in the European Court of Justice ruled that employers need to keep records of daily working hours of each worker, including rest breaks. The regulations clarify that this is not necessary. Employees may create and maintain records in such manner and format as the employer reasonably thinks fit, as long as they are sufficient to show compliance with the working time regulations. However, it may still be vital to keep records in relation to health and safety requirements.
There are a lot of kind of, quite handy and useful kind of changes there. So, I mean, have you got any other kind of practical ideas or tips that organisations could be thinking about now in relation to changes to holiday pay?
Definitely. So if you have a part-year or any part-time irregular hour workers and want to change how their holiday is calculated or paid, you'll need to issue new contracts to reflect those changes, and you'll need to get their agreement to amend those contracts. And if you have obviously more than 20 staff, you'll need to carry a collective consultation in relation to that too. Additionally, you do not need to change your contracts if you want to just calculate the way that you're calculating holiday pay. That can be done. We're not requiring any consent to amend their contract of employment. And also, obviously, you can continue to offer more generous holiday pay than the statutory requirements. That's absolutely fine too. In terms of rolled up holiday pay, obviously this is a new thing that was previously unlawful. So if you are minded to go through with that, if you do implement it, you'll need to make sure that it's evidenced on your pay slips. And you should ensure that workers who received holiday pay still take holiday. That's really important. And you have a duty to make a safe environment and include this ensuring workers are given the opportunity to rest and relax.
Cool. And I mentioned at the beginning potential for a general election this year. Like in the last few days, there's been kind of tons of press reports about what kind of the Labour Party are thinking of introducing. What have been kind of some of the kind of major ones that you've picked out?
Oh yeah, quite a lot going on. I'm sure everyone's read what might be coming through this year. So one of them would be a right not to be unfairly dismissed from day one of employment. It's obviously currently about 2 years, so that would obviously create a lot of more potential tribunal claims there if everyone has the right to bring an unfair dismissal claim. And ban on 0 hours contracts is also a big one that they're tabling, and strengthening trade union rights, including a right of entry to workplaces. And obviously, Aston's already mentioned the strengthening harassment laws is already going through, but there are discussions about further enhancing those too. So I think there's a lot just with those, and I know there's many more potentials that Labour have tabled that they want to put forward if they do get through this election.
Yeah, I think we saw the potential for equal pay legislation to be extended to kind of other protected characteristics as well. So, if there is a change in government later this year, I think 2025 might be an even busier year for HR teams than this year. So there'll be lot to prepare for sure.
Our 2025 update will probably be significantly longer.
Yeah, might have to be a series of them if everything comes through. Cool.
Thank you. Next slide, please, Megan. So as Aston mentioned, there was obviously updates to the Equality Act, and I'll just be mentioning a few more of those. So on the 1st of January 2024, regulations amending the Equality Act 2010 took effect. The Equality Act 2010 and the regulations of 2023 are intended to reproduce in domestic law certain interpretive effects retained in EU law as interpreted by court judgments, which provide protection against discrimination, which otherwise would cease from the end of 2023. So it's very much trying to keep us in the same place that we were before and adding a little bit more rather than going backwards. This ensures that current protections in relation to pregnancy, maternity discrimination, equal pay, disability discrimination, and indirect discrimination continue to apply. So what has been amended? So the definition of disability has been amended in reference to the ability to carry out normal day-to-day activities. This now includes the ability to participate fully and effectively in work life on an equal basis with other workers. There is also a new section 19A in the Equality Act, and this section enables someone with a protected characteristic, protected characteristic to bring indirect discrimination claim if the PCP puts them or would put them at substantively the same disadvantage as people who do have that relevant protected characteristic. So very important there, they do not actually need to have that protected characteristic themselves. And there's been a new single source test for establishing equal pay comparison is also preserved. Terms are attributable to a single body responsible for alleged pay inequality, which can restore equal treatment, or where terms are governed by the same collective agreement. And it's also been confirmed in relation to less favourable treatment on the grounds of breastfeeding, and that is amounting to direct discrimination on the grounds of sex. Women are also protected from unfavourable treatment after the end of maternity leave, where treatment is in connection with pregnancy or pregnancy-related illness during the protected period. And further, a general discriminatory statement made in connection with recruitment decision may be direct discrimination, even when no active recruitment process underway or there's been no identifiable victim. So there's a very good key updates into the Equality Act, and obviously, like I said, it's keeping us where we are and building upon that. Next slide, please, Megan. So trade unions, there has been a change to trade union checkoff that's going to come into play on the 9th of May 2024. So what is a checkoff? A checkoff refers to union subscriptions deductions from members' salaries by employers, which is paid over to the unions. So effective employers will only be able to operate checkoff systems themselves where two conditions are met. One being affected workers will have the option to pay their subscriptions by other means. And secondly, arrangements have been made for unions to pay reasonable payment to employer to cover the cost of the checkoff. So really to cover that admin process. And next slide, please. Pensions, so auto-enrolment, we'll just touch on it briefly here. The amendment received royal assent on the 18th of September last year, and it will have effect at lowering the age of which eligible workers must be automatically enrolled, and that's going down from 22 to being 18. And it's also the minimum threshold currently 6,240 is also likely to be removed. There will be a consultation in due course on this, so that's very much kind of in the pipeline. Next slide, please. So fire and hire, we've seen kind of in recent months, there's been a lot of coverage of this in the press. So the consultation on statutory code of practice on dismissal and re-engagement, fire and hire, closed on the 8th of April 2023, but to date there has been no government response. The code of practice on fire and hire was introduced in 2023 in response to those heightened attention on the practice of using that. The final version is expected to be published early this year, so watch out if you're looking to change any contractual terms imminently. It could mean that tribunals are required to take the code into account where relevant in any proceedings, and there could also be an adjustment to compensation, such as up to by 25% uplift. So that's really a one to kind of look out for going forwards. And if you do want to make any contractual changes, it's a good time to do it before this comes into play. So next slide, please. So restrictions on non-compete clauses. On the 12th of May 2023, the government responded to a 2020 consultation regarding reforming of post-termination non-compete clauses in contracts of employment. They confirmed their intention was to introduce a statutory cap of 3 months on non-compete clauses, but it will be picked up again when parliamentary time allows. So as we know, to date, there's been no update on this. So it's really unclear as to whether this is actually going to go ahead. It is really important to have in mind when drafting contracts that the restrictions need to be reasonable for the role that you're hiring for, and be mindful that if you're going to go for a period at the upper limit here, that actually this might then come into play and you'll need to take review accordingly, but really to in each and every occasion to review what's necessary for a restrictive covenant and not just go as in some cases we've seen to go up to kind of 12 months. It's better to make sure that you're reviewing each and every one on a case-by-case basis. I will just hand over to Aston, and she's going to provide a summary of the updates of what we're expecting in 2024.
Thanks, Zoe. So just a final quick few words from me in summary before we pass to Charlotte. So for ease of reference, you'll see on the slide all of the changes that Zoe and I have talked about this morning and when they're expected to come into force. You'll see that some of them are still to be confirmed in terms of the changes, but it will be a very busy month in April. As such, it definitely makes sense to start getting prepared for these changes sooner rather than later. We'd recommend conducting a review of internal procedures, contracts, policies, and systems as soon as you can. Within that exercise, you can consider any areas of risk or improvement, so in relation to holiday leave and pay tracking, for example, as well as anything that you might want to build on, such as neonatal leave and pay. Harassment protocols and restructuring processes will be of particular importance. So thinking about these at an early stage will pay dividends or save them, as the case may be, later down the line. And we are available and ready to discuss any of these in more detail if you need any help with that review process itself. So that's everything from Zoe and I for now, and we'll pass things over to Charlotte to talk through some cases.
Thank you, Aston, and good morning, everyone. So in this update, we have identified some of the key cases which we think will have a big impact on employment law and HR policies and practices over the next 12 months. So today I'll be covering 2 cases on gender identity beliefs, which have had considerable media coverage, although I may just cover one of these as I'm quite conscious of the time. But I'll also discuss the judgment which questioned whether parties can agree to settle future employment claims via settlement agreements, whether striking workers are protected from a detriment short of dismissal under the Trade Union and Labour Relations Act 1992. And whilst not a judgment, we think it's only fitting to touch on the government's consultation on reintroducing fees to bring a claim in the Employment Tribunal and Appeal Tribunal. Next slide, please. So dealing with fundamental differences in values and beliefs that emerge between colleagues is not easy to deal with. And we've seen a sharp increase in these types of claims by claimants who allege they've been dismissed, undermined, or treated unfairly for expressing so-called gender critical beliefs. So what I mean by gender critical beliefs is the belief that sex is immutable and can't be changed. Now, whilst workers have an absolute right to hold their beliefs at work, they don't have the same absolute right to express those beliefs, and employers can impose restrictions on what workers can say. But these must be reasonable and they must be able to justify this. So it's a difficult balance to strike out, but courtesy of the EAT in Higgs and Farmers School, we do now have some helpful guidance as to how employers can proportionately intervene, although I must stress that there's no one-size-fits-all approach here, and each case does turn on its own facts. So if we do turn to the facts then in Higgs and Farmers School, so the claimant worked as a pastoral administrator and work experience manager at Farmers School. Her position was in direct contact with children, and she reposted someone else's post on her Facebook page, which said that the government's consultation on relationship and sex education in primary school normalised single-sex relationships, presented gender as a matter of choice, suppressed Christianity, and brainwashed children. Basically, a parent caught sight of this post and complained to the school, and the claimant went through a disciplinary process and the school dismissed her for gross misconduct. It said that she'd breached its written code of conduct, which prohibited illegal discrimination and social media posts which could bring the school into disrepute. So the claimant brought a claim against the school for direct discrimination on the grounds of religion and belief, under Section 13 of the Equality Act 2010 and harassment under Section 26 of the Equality Act. The employment tribunal actually dismissed her claim. It said that she had been dismissed for the way in which she had expressed her protected beliefs, not because she held those beliefs. The claimant appealed this decision, and the Employment Appeal Tribunal disagreed with the tribunal's findings. It basically said that the protection is not limited to just allowing people to hold specific beliefs, but it extends to the way they manifest those beliefs. Manifest in this context means making their beliefs known to others through actions or words. However, the EAT also explained that these rights can be limited or restricted by law to meet a legitimate aim and where it's necessary in a democratic society. So applying this to the facts of the case, the EAT said that the tribunal should have asked itself whether the claimant was dismissed because of or for a reason that related to the way she had actually expressed her protected beliefs. And to answer this, it needed to decide if there was a close enough connection between the claimant's beliefs and her post. And the tribunal just hadn't properly answered this question. Another key question was whether the school could justify limiting the claimant's right to express her beliefs in the way it had. Again, the tribunal hadn't dealt with this either, and the EAT has remitted the case to the tribunal to determine, and a full hearing date is awaited. So why does this case matter? I mean, although we don't know whether the claimant will ultimately succeed with her claim, the EAT has set out some guidance on how to assess the proportionality of any interference or restrictions with the right to freedom of belief and expression. And the EAT suggests factoring in the content, the tone, and the extent of the employee's statement or action, the likely audience, the extent and nature of the intrusion on the rights of others, the impact on an employer's ability to run its business, and whether the employee has made it clear that the views are personal, and whether there's a risk of reputational damage. When we talk about restrictions here, it can include like employer policies and procedures, and provided that they're accessible to staff, and they explain that what could happen if they disobey the rules. In any event, I think employers would need to objectively justify any restrictions it imposes on its staff, and provided it can do so, it may well be able to discipline staff if they express themselves inappropriately. So while this guidance helps employers kind of ask the right questions, it will be interesting to see how the tribunal applies its guidance to this case. Next slide, please. I'm quite conscious of time, and the facts are very similar. So if it's okay, I'm just going to skip this slide and go to the next case. Okay, so as many of you know, a settlement agreement agrees in exchange for financial settlement that the employee will not bring any claims against their employer and will discontinue any they have started. To validly waive most employment claims, the settlement agreement has to be in writing and relate to a particular complaint. Now, in Bathgate and Technip, the Scottish Court of Session had to determine if an employer could rely on a clause in a settlement agreement which purported to prevent the employee from being able to bring any future claims unknown at the date of settlement. And when we talk about future unknown claims, what we mean here is any claims that exist at the date of settlement, or where the facts necessary to bring the claim exist, but the employee is unaware of either or both. Claims that don't exist at the date of settlement, and where the facts necessary to bring the claim only arise after the settlement date. And claims that don't exist at the date of the settlement, but new legislation or legal decisions after the date of settlement enable a new claim to be brought. So in this scenario, as a result of a redundancy exercise, the claimant was dismissed, and at the age of 61 in January 2017, he entered into a settlement agreement. Now, the settlement agreement waived a large number of statutory and other employment claims, including claims for direct and indirect age discrimination under Section 120 of the Equality Act. And under the settlement agreement, the claimant was paid an initial payment on the date of the agreement, but was due a second payment in June 2017. And prior to the second payment, the respondent decided that it could only be made to employees who were 60 or under. Now, the claimant was 61 at the date of the settlement agreement and termination of employment, so he therefore couldn't receive the second payment entirely because of his age. So he brought a new claim for age discrimination for the second payment, but the respondent argued that any such claim was prohibited by the settlement agreement. Now, the claimant argued that future unknown claims were not covered by the settlement agreement, and he referred to the wording of Section 147 of the Equality Act, which basically regulates settlement agreements, and in particular, Section 147(3)(b), which requires that the settlement agreement must relate to that the particular complaint. The claimant basically argued that a generic reference to age discrimination claims under Section 120 of the Equality Act was not the particular complaint he was bringing. So the case went to the Scottish Court of Session, and in November 2023, the Court of Session disagreed with the EAT's decision. The court basically said that the correct position was set out by the EAT in Hilton UK Hotels Limited and McNaughton. That is a future claim of which an employee does not and could not know about may be covered by a waiver where it is plain and unequivocal that this was what the parties intended. It therefore decided that Mr. Bathgate could not proceed with his claim because it had been validly settled under the terms of the settlement agreement. I think this is possibly the clearest decision on settlement agreements and unknown future claims. And although this decision is not technically binding on tribunals in England and Wales, it is very persuasive, and we expect tribunals in these jurisdictions to follow it. So with that in mind, it is probably a good time to review all template settlement agreements and just make sure it reflects the parties' intentions. Next slide, please. Next, I want to discuss a case that we actually mentioned in our 2023 webinar that took place this time last year, and that is the case of Mercer and Alternative Future Group Limited, and it asked the question as to whether employers are allowed under the Trade Union and Labour Relations Act 1992 to dissuade employees from going on strike. Nick, sorry, I'm quite conscious of time. Is it okay if I carry on with this and go on to the tribunal fees?
Yeah, absolutely. Yeah.
Okay, thanks everyone for bearing with me. Now, an employee who takes part in a lawful strike is protected against being dismissed for that purpose. But the position is less clear where they are suspended or disciplined in an attempt to prevent or deter them from going on strike. So Section 146 of the Trade Union and Labour Relations Act 1992 protects employees against detriment because they are a member of a trade union or have taken part in activities linked to a trade union. So could a relevant employee rely on Section 146 in this instance? Well, the Court of Appeal in this case held that an employee who was subjected to a detriment, short of being dismissed, for taking part in industrial action couldn't bring a claim under Section 146. It went on to say that this may put the UK in breach of Article 11 of the European Convention on Human Rights, which gives the right to join a trade union and prevents disproportionate and unjustified action taken against them for doing so, but it couldn't rewrite the law to comply with this. So the Supreme Court heard the case on the 12th and 13th of December 2023, and we await judgment. From January to October 2023, this statistic quite surprised me, but almost 2.5 million working days were lost due to strikes, and these high levels looked set to continue in 2024 as well. It's not unusual for employers to remove discretionary benefits from workers and or subject them to other detriments in an attempt to deter them from taking part in strike action. So if the Supreme Court does rule that Section 146 can be interpreted in line with Article 11, employees will be able to issue claims in the Employment Tribunal to obtain compensation for their losses as a result of being subjected to detriments. Next slide, please. So finally, and I'll go through this quite quickly, the topic of employment tribunal fees seems to be back on the table following the government's opening of a consultation paper, which it is seeking feedback on as to whether we reintroduce fees in the Employment Tribunal and Employment Appeal Tribunal. If successful, it may be introduced in around November 2024. Therefore, we just thought it would be helpful to provide you with the key takeaways from this paper. So the first question that springs to mind is, why are the government trying to reintroduce employment tribunal fees? And there seems to be a couple of reasons here. One is to reduce the cost to the taxpayer to fund tribunal services. And the other is to incentivise parties to settle disputes at an early stage and encourage better engagement in the ACAS early conciliation, and kind of alleviate some pressure from the tribunal, especially following COVID-19. The government says that the fee will be modest. Now, when fees were introduced in July 2013, the amount payable by a claimant or appellant depended on the nature of their claim and how complex it was, and so it could have been a hearing fee of anything from around £160 to £1,200. As you'll recall, the Supreme Court held that fees such as this prevented access to justice, and so they were quashed. I think the government have tried to acknowledge that. And so the paper proposes that a fee of £55 to bring an ET claim and an appeal. There is an exemption, which is if an individual is claiming for a right to payment from the National Insurance Fund, which is usually where an employer is insolvent. Now, if a claimant is unable to pay the fees due to not having sufficient disposable funds, then they would be eligible for a partial or fee for remission under the existing Help with Fees scheme. And with this introduction of fees, the general approach to costs in that each party pays its own legal expenses remains the same.
Thanks, Charlotte. Do you think these changes, or if they do come into force, will have a similar type of impact as they did kind of last time around?
Yeah, that's a really good question. I think the proposal has actually already met some pushback from what I've seen, particularly from some unions, and that reintroducing fees just looks like the government's kind of taking sides with the employers over workers who are just trying to exercise their rights. As in 2013, we did see a massive drop in employment tribunal cases, and I think we will see a drop in claims being brought. But given the lower hearing fee, I just wonder whether the drop in claims would be as large, and even with the cost of living crisis as well. I think a positive from this, though, would be that the fee may prompt claimants to consider the merits of their claims before issuing, or they may utilise the ACAS conciliation route to its full potential a bit more.
Great. Well, thank you very much. Look, I'm conscious that we've just ticked over the hour mark, so I will let you all go back to your busy days now. I'd just like to thank Aston, Zoe and Charlotte, who have covered so much this morning, and to Megan, who's been working really hard behind the scenes, making everything run smoothly. Apologies for not getting through all of your kind of questions today. As I mentioned earlier, we'll be sending out an email in the next few days, providing a fuller response to the points that we've discussed, and picking up, the questions that you've asked. We'll also be sending out a recording of the webinar. That just kind of leaves me to say thank you very much for joining us, for asking such brilliant questions. It's really great to see how you think these changes might affect you in 2024 and what they may have in store for you. We'll be hosting another employment briefing shortly, so please do look out for the invites to that. In the meantime, again, thank you very much for joining us. Have a great day, and we look forward to seeing you soon. Thank you. Goodbye.